Good afternoon, everybody. Welcome to today's latest webinar with Giant about all things in the Netherlands from a contractor perspective. We'll do the usual piece and just wait a few seconds or so as people are joining the call. If you're new to the Giant webinar series, then the format is generally speaking similar across all the sessions, where we'll go through some set questions and then move into Q&A. So if you can see at the top of your screen, there's a Q&A button in order for you to put any questions into our experts as we go through the session. If you've come onto the call today with any burning questions about the law in relation to the Netherlands and contractors, then please do put those questions in, and we'll make sure that we weave them in on the Q&A section towards the end of today. Still got a couple more people coming in. Don't be strangers as well. I'm sure there'll be people registering in and attending from both the UK and maybe over in the Netherlands as well. So feel free to say hello in the chat and introduce yourself. But it looks like the joiner numbers are starting to slow a little bit now. So I think we're in good shape to start the session. So thank you for joining us today, and welcome to this webinar, which is all about working with contractors in the Netherlands, specifically looking at the DBA law and the enforcement action around that, as well as signposting some future legislation for us all to be aware of. And today we're going to focus on the compliance and the legal considerations that you should be aware of when businesses are looking at hiring workers in the Netherlands, not just now, but also in the future. So the format for today will be that there's probably going to be a mixture of recruitment businesses and end hirers that are joining us. So over the next sort of 45 minutes, we'll look at the considerations for businesses that are looking to engage temporary workers, with a specific focus on worker classification, which is always a hot topic on these sessions. So we'll look at the rules around that in the Netherlands, which is the DBA, the vet DBA law, and also how that's being applied by the Dutch government, who are now looking at trying to increase their enforcement activity around those rules. So it'll be interesting to see how that impacts the market. I think generally speaking, it's worth noting that over the past decade, the number of freelancers that have worked in the Netherlands has grown exponentially by over 85%, according to the Dutch Chamber of Commerce, known as the KVK. They believe there's about 1.2 million self-employed people that operate in the Netherlands. And generally speaking, I think the Netherlands is regarded as a contractor-friendly country to operate in. However, it is estimated that 13% of self-employed individuals may be classified as falsely self-employed, particularly in sectors like public sector, IT, media and communication. I also saw that the SIA and the Netherlands Times were reporting that there's probably about 21,000 self-employed workers in the Netherlands who've actually started to look at closing down the business at the start of the year, in relation to those contractors worried about additional enforcement activity that might be coming through around the DBA rules on misclassification. So when you think about that in terms of additional legislation in a marketplace which is already extremely tight in terms of available talent, and that's many countries, including the Netherlands and the UK, then it's a challenge for the Netherlands labour market and people that want to operate there. So hopefully we can give some insight around some of those themes through the topics that we're planning on covering. So the list of topics that we've got today is to look at the DBA Act itself and what's changing, look at how the legislation is going to be enforced, and that's a little bit of a moving feast as there's a little bit of political movement in the Netherlands. We'll then look to see and anticipate how the market might react to these changes, what companies can do to reduce their risk and the ways that they can look at engaging workers moving forward. We'll also have a look at the various types of providers who can help supply those workers and take on some of these risks away from recruitment businesses and then hirers. And then finally, we'll finish by looking at future licensing requirements that are going to be on the horizon in the Netherlands in the coming years. And I think that will be of interest in particular to the recruitment businesses that are joining us today. So we do hope there'll be lots of questions, so please do send them in via the Q&A button, and we'll try and leave 15 minutes or so at the end of the session and to cover those questions off. So today's session is obviously brought to you by Giant Group. Giant are a leading contingent workforce management company. We've been operating now for nearly 35 years, and we help lots of different types of businesses manage their contingent workforces, both in the UK but globally, including the Netherlands. And we're also delighted to be joined today by Osborne Clarke. If you don't know who Osborne Clarke is, they're an international law firm who advise on a wide range of matters, including employment and tax law considerations, in particular involved in the temporary labour market. So our speakers today, we've got Jorgo Tsiris. Jorgo is a partner at the Osborne Clarke Netherlands office. He specialises in workforce solutions, cross-border projects, incentives and corporate employment law. We're also joined by Jorgo's colleague Meryl Kaiser, who's an associate of Osborne Clarke's Netherlands office. Her daily practice as an attorney covers various topics, but she specialises again in flexible labour relations, on which topic she also obtained a PhD. So from Giant, we have Charles Dorr. Charles is Sales Director for Giant Global, our global employer of record and agent of record business. Charles focuses on helping customers access talent globally and compliantly using Giant's international payroll services. Clients include UK recruitment businesses placing internationally, as well as end hirers that are also looking at tapping into global talent pools. My name's Dan Haslam. I'm Chief Business Development Officer here at Giant, and I'll be the host for today's webinar. So the format is going to be very straightforward. Jorgo, Meryl and Charles will address a number of set questions which I'll put to them in order to steer us through the topics that we'd like to cover today. Once we've gone through those topics, we'll then move into the Q&A. So please do submit those questions so we can get around answering those towards the end of the session. And yeah, I think we're in a good place now to start and kick off. So let's begin then firstly looking at the worker classification rules, or the VET DBA legislation, and how that should be applied when considering tax status in the Netherlands. Good afternoon, Jorgo.
Good afternoon, Dan.
Jorgo, just if you can kick us off then, please, by giving us an overview of the legislation and how the Dutch government are sort of thinking about changing their approach to enforcement, please.
Yes, I'm happy to do so. So maybe to start, in the Netherlands, workers qualify as employees if they perform work for a company under the supervision of this company, and in return for which the worker then receives a salary. So it's three criteria. It's work, salary, and supervision. In practice, when classifying a worker as either an employee or a self-employed worker, most discussion often exists regarding the criterion of supervision. This element of supervision is what actually distinguishes employees and self-employed workers. Self-employed workers may be given instructions regarding the end result of the work that is assigned to them, but these instructions must not be so extensive that it can be considered as supervision over the way the work is performed and the worker, him or herself. If it does, it will be considered supervision and will be an important indication for qualification as an employee. As said, self-employed workers often work for user companies via intermediaries. In that case, practice shows that both the user company and the intermediate company are at risk of being qualified as an employer. Both parties should be aware of this qualification risk. An intermediate company may be seen as a temporary work agency, or in Dutch, uitzendonderneming. The more involved an intermediary is in the performance of the agreement between a self-employed person and a user company, e.g., facilitating invoicing, payment, hour registration, absences, illness, etc., the higher the chances are that the intermediary might be labeled as an employer. The intermediary can then be considered to be a regular employer, but can also be qualified as a temporary work agency or payrolling agency. It doesn't matter then that the worker is self-employed. Recent case law shows that self-employed workers can be considered assigned by an agency to a user company as well. Thank you, Dan.
Great. Thanks, Jorgen. I think that's useful just to sort of set out at a high level the considerations there. But going in specifically then to how the Dutch government are looking at approaching enforcement activity here, can you give us a little bit of an insight there as to how that is being approached and how that might be changing?
Yes, sure. So maybe as for starters, the current legislation has not yet changed. There is a lot of proposals and bills going on, but nothing has entered into law yet. A very famous proposal is the Weber Act, and it's still unclear if that will become law or not. As I said, most recently there was another decree opened for internet consultation for people to react to. It's actually, you can find it on the internet. So I'm just making clear that it's still a debate within the parliament and also within society. We can't predict what kind of new cabinet we will have. There are general elections at the end of October in the Netherlands. In our view, the political climate is not very stable. For example, a few months ago, the Ministry of Finance communicated that they themselves will keep working with self-employed workers, where at the same time they try to ban that from the labor market. So in my view, it's still very unpredictable how this will play out. In terms of enforcement of the DBA, the ban, the so-called enforcement moratorium, has been lifted. I think everyone knows that. But in 25, so the year 25, the tax authorities haven't done much other than trying to warn or direct or to inform certain companies that are at risk to clean up their contractual act, so to speak. But no fines have been levied, and it's still a little bit in the startup phase. In 24, actually, the tax authorities published a updated enforcement plan, which the link of that you can find in the podcast notes. And from that plan, it follows what I just said, that no fines have been imposed. And the regular enforcement rules, actually, meaning fines, will start according to that plan in 26. So there is still time for our listeners or other companies to adjust their working practices if necessary. There is also the model agreement still. I think the audience know what that is. And if the model agreements are approved, they will remain valid until the end of 29. No new applications or extensions will be considered after 6 September 24. And to model agreements, we say it provides certainty upfront if the client and contractor adhere to the agreed terms. So in practice, the model agreement needs to be lived by in order to provide the certainty that it's supposed to give to the contracting parties.
Okay, so just to recap then, just on what you were saying there on the enforcement activity, because there was a general sense that the Dutch authorities had said from the start of 2025, we're going to be paying a little bit more attention to how businesses are viewing misclassification and how they're engaging contractors. And they were sort of almost giving a bit of an amnesty there to the market to say, get your house in order. And then we're going to start looking at being a little bit more aggressive and potentially putting fines in place. What you're saying is that they're still really in that mode. They're not really defining to anyone to say we're going to take stronger action at this point. However, you're also noting that there's an election in the Netherlands in a month or two's time, and obviously that could have a big bearing on whether or not they decide to be more lenient or if they want to take more action on this matter. Was that a fair summary?
Yeah, that's a very good summary, Dan. Thanks for that.
Okay, great. Okay, so given that landscape then, which is obviously a little bit noisy and a little bit confused in some respects, have you seen any particular early reactions from employers in the Netherlands in how they're reacting or pivoting around the government's approach?
Yeah. So especially, for example, in the healthcare sector, hospitals,
Yeah,
basically the reaction there was to try to employ everyone, right? So self-employed workers were really outcast a little bit in that sector. In other sectors, parties have tried to remain flexible, sometimes using an intermediate to put in between the worker and the client or the principal. So those are two approaches that we have seen coming from the market. So either going into straight employment, as in the healthcare sector and other sectors maybe, or try to remain flexible, but in order to reduce risk on the reclassification, put in an intermediate. That's the two, I think, main flavors that at least I have seen. Yeah, it's still advisable for our listeners to map out your current flexible workforce and see what kind of workers are at risk of requalification. And on top of that, we still take the position that there is a good grounds for people listening to this podcast to stay put for the time being,
yeah,
because as Dan already said, it's still unclear what kind of direction this country will take in terms of the discussion that we're having. And that's basically what we have been saying up to date now on this point.
yeah. Good. Well, I mean, I suppose it's nice to hear actually that in a very tight labour market where in most European countries there's a lack of jobs and there's a little bit of stagnant economic growth, that actually the Netherlands government are taking a pragmatic view of just taking the foot off the gas a little bit here and not adding any more friction in. Certainly not necessarily the case sometimes in the UK. So I think it's going to be interesting to see how the Dutch market reacts, and whether our experiences, I suppose, in the UK post our IR35 legislation changes of give any insight into how the market might react or adapt when the Dutch authorities do take a more rigid view. I mean, some of the key themes that we saw obviously around that were large corporates wanting to avoid the investigations, and so just basically moving to employed models like you described around the healthcare piece. But of course, as you also pointed out, that then does have an impact on supply and demand. Often it'll push up the rates that are involved for contractors because you've obviously got employment taxes that come to bear. And of course, in the public sector, I'm sure it's as a tight budget in the Netherlands as it is in the UK. So there's a lot of commercial things to factor in that pivot off the back of this misclassification piece. So thanks for setting the scene there, Yorgo, and going through some of those behaviours. Charles, it'd be great if I can bring you in here now and sort of get some of your insight in what your clients have been saying about the changes and their appetite for hiring contractors in the Netherlands.
Yeah, for sure. Hopefully you can hear me okay. You're sounding like you're underwater to me, so I'm not sure if it's my microphone on my laptop that is playing up, but hopefully you can hear me okay.
It's a little, yeah, we can hear you okay. It's a bit croaky, but we'll put it down to your age, Charles.
Thanks very much. So I guess we started talking to our clients about the change in enforcement towards the end of last year. And I guess the first reaction was that it wasn't widely known about. Many of the UK recruitment agencies we spoke to weren't aware that there was going to be more focus by the Dutch authorities on this area, and that the moratorium was coming to an end. And I guess it's not something that was widely advertised by the authorities to overseas companies, not that it would be. The next reaction was pretty much as you would expect, a little bit of denial that it wouldn't affect them and that they would just continue working as they normally do. But we did a lot of follow-up with links to articles about the changes, and the penny was definitely starting to drop. But this is a significant change and something that needed to be addressed. So I would say that the Netherlands has always been a little bit different to many countries in Europe, in that they've always had the chain law in place. which holds everyone within a contract chain jointly liable for the payment of tax of a contractor. And this has meant that there's been, I guess, a lot more leaning towards the employment model compared to other countries. They've also had incentives like the 30% ruling that has made using the employed model for non-Dutch nationals more inviting. So I think the split between what we call EOR and AOR has always been a bit more even in the Netherlands compared to other countries. And I think this change will certainly move the dial even further towards the EOR model.
Yeah. No, I think that's logical, isn't it? If we're already heading in that direction, then any enforcement activity will just continue to drive employer of record. And again, that's not just in the Netherlands, but many countries seem to be pushing businesses to err more on the side of caution there around employment, and because of course they're taking more tax, and that helps with things like with pension deficits, which is a problem across many European countries. So thanks for that. Jorgo, any final comment from you then in how the current elections in Netherlands could impact this approach to future enforcement activity? And I don't know if that's Jorgo to come in, or Meryl, if you want to contribute here as well.
Well, I like to contribute as well, Dan. Thank you.
Thanks.
I'll have a quick note on that. So I think Jorgo already mentioned a lot in regard to our government and their enforcement actions, or action to not enforce, actually. I do think it's fair to say that it remains uncertain whether and to which extent our government in its current or future form will be able to come to consensus on the approach and the legislative proposals that are pending right now on self-employed persons, but actually all flexible labor relations, which are a lot in the Netherlands. However, I think on the other hand, it's also realistic that self-employed workers or people who are considering to work as self-employed person will think twice about doing so, because the government did recently, last week actually, announce certain concrete plans regarding the benefits, tax benefits that self-employed persons enjoy, and the proposed obligated mandatory disability insurance for self-employed persons. So these tax benefits will be decreased, so they will be lowered, and the contributions from self-employed persons to those mandatory disability insurances are considered quite high. In addition, the coverage of these insurances when the self-employed workers become permanently disabled to work is below the statutory minimum wage. So there's a bit of concern, for self-employed persons with regard to the costs that insurance will introduce, and also with regard to the lowering of the tax benefit they are now enjoying. So it's realistic to say that may be an important factor that will decrease the attractiveness of being self-employed in the Netherlands.
Yeah, that's a great point, Meryl. It's like a two-pronged attack, isn't it? So on the one hand, top down, you've got the government signposting, oh well, we're looking at, at some point we'll tighten up on this enforcement activity, and then on the other hand, reducing the differential between the take-home pay for the worker between self-employed and employed also reduces the attractiveness of operating in that way. So I think that feeds into what Charles was saying, that the direction of travel certainly looks like it's preferable for employed models for contractors in the Netherlands. So thanks, Meryl. Charles, I think that's probably a good segue actually into our next topic, which is looking at practical ways that businesses can reduce their risks in this area, and maybe costs as well. Anything in particular that you're advising at the moment to help clients reduce their risk on this particular topic?
Yeah, I think the first point is to really consider the way the end client is going to engage the contract resource. Actually interrogate, is this a truly independent contractor, or is there a level of supervision that would put them kind of squarely in the employment bracket? So, not just taking the word of the contractor when they say that they've got their self-employed registration in place and that's how they've always worked. I think you need to put that extra level of scrutiny in there. And one of the things that we've done is we've put together a questionnaire that can help to clarify and give guidance on which type of solution should be used. And I guess the caveat, as always, is to say that it will always be the reality of what's happening on site, as opposed to the answers on a questionnaire or even how a contract's written that the authorities will look at. So the way to really reduce and mitigate risk is to use an employed model. With an EOR service, the Dutch government essentially receiving full employment contributions, and the contractors having all taxes deducted at source and paid directly to the authorities. So there's kind of no wiggle room. It's kind of a full belt and braces solution, and does take away the risk of reclassification. But I do appreciate that's not always how everybody will want to work. There will be people who want the flexibility of self-employed. So I think just having that level of due diligence and actually asking some in-depth questions about how the resource is going to be engaged is really super important.
Yeah, it's that familiar tension between no risk but high cost versus high risk but lower costs, and it's often the commercials that are dictating some of the behaviours here in how businesses want to engage contractors. And it's, I suppose, for the companies that are on the call today to sort of figure through what where they sit on that spectrum, basically. Just as a reminder to everyone who's on the call, please do submit your questions into the Q&A box, and then we can come round to those at the end of the session. If there's anything in particular that you guys are thinking about around setting up in the Netherlands or engaging workers there, then please do chuck the questions in, and we'll make sure that we can pose them to our experts at the end of the topics. So thanks, Charles, for your comment there. So Jorgo, just the same question to you, if I may, which is, again, what advice and practical tips would you share with your clients and today's audience to help them reduce some of these compliance risks that we're highlighting?
Yes, thank you, Dan. So as Meryl already said, the political climate currently, although chaotic, seems to be focused on limiting working with self-employed workers, especially when the self-employed workers perform work that can be considered as core activities of the user company. But nevertheless, we always say that it's still possible to engage with self-employed workers, either through a intermediary, as you said, maybe the costs go a bit higher, risk go a bit lower, but also in a direct engagement, it's still possible to work with self-employed workers. No one has said that it's illegal, but clients or customers or people listening to this podcast should take in consideration a few things, and that's about the requalification risk. And there is still a few circumstances that are relevant to assess before engaging with a self-employed worker. And I just will mention a few. First of all, make sure that the contractor is registered as such in the Chamber of Commerce as an entrepreneur. Second, have the contractor send invoices with VAT. Third, make sure a clearly defined result, statement of work, is agreed upon with the contractor, and also make clear that the contractor is free to a certain extent in how to reach that result. 4, make sure that the contractor has the freedom to work for other parties, so no non-competes if possible, and also that the contractor has the possibility to have someone else do the work, although that's sometimes difficult, but it's still a circumstance that count in these. other point is that the instructions, we talked about it a lot. It's not forbidden to instruct the contractor on the end results. You should just stay away from instructions on the how to do it. Make sure that the contractor brings his own stuff, his own supplies, his own hammer, his own laptop, his own phone. You should definitely not invite him to your Christmas party. And lastly, avoid, if possible, an email address linking to your company, etc., etc., etc. It all makes sense maybe to a certain extent, but we see in practice a lot of stuff in cases where this goes wrong, and the court uses these kind of examples to relabel a self-employed worker into an employment relationship with all liabilities that come with that. Maybe in some, it's important to avoid the the self-employed worker to be embedded. So that means that ideally the self-employed worker would do work which is not considered to be the core activity of the company. That will help a lot to stay away from reclassification. And that's basically what we have been advising our clients so far on this point, Dan.
Yeah. Well, I think they're all very sensible suggestions, and actually aligns very much to the same sort of advice that we see over in the UK for businesses when they're, trying to ensure that they're not allowing a worker to become part and parcel of the organisation, and therefore start to blur the line between contractor versus employed. You also made a good point, I think, around the way that you can ask for the work to be done and try and construct that around a deliverables based approach, or a statement of work as it's often described, where a contractor is being asked for specific outcomes and delivery there, as opposed to just, hourly and day rates that are agreed, and then they turn up for work and they do whatever's put in front of them on that day. I think there are many reasons why businesses are looking to try and position contractors to deliver more on outcomes where they can, but of course that's not always easy in practice. So I think they're all sensible suggestions around how to sort of reduce the risk there. And again, it's just thinking about how that can fit into your organisation, because the main theme is how do we get the work done, right? And that's got to be done in a way that delivers the project, but also is palatable to those that are doing the work. So thanks, Jorgo. Charles, if I can bring you back in here. How do you help your clients then, and what are the typical behaviours that you see from businesses from a global, that deal in global payroll, particularly around classification?
Yeah, it's interesting because if I go back to when I first started working in this industry, then the self-employed was absolutely the main way of working for contractors around the whole of Europe. But we've certainly seen more and more governments bringing in legislation to move temporary workers into an employed option. And of course, as we've mentioned, the reason behind that is that governments collect more tax and social security from an employed solution compared to self-employed. Over here, as you just mentioned, in the UK, we have the IR35 legislation. And what we've done is really used IR35. We've used the WAB legislation in the Netherlands, also AUG legislation from Germany, and worker misclassification rules in the US. And we've kind of developed an international version of an IR35 test for international contractors. Well, I guess as we always like to make sure we clarify, it's not a legally binding document in any way, but what it is aiming to do is really just give a good guide as to if someone should be engaged as a freelancer or via an employed model. So what we're looking to do is kind of put that extra layer of due diligence into assessing how to engage the temporary workers, which shows that you're following a process and making a decision based on the reality of the engagement, as opposed to just going for the cheapest option. And overall, we feel that's a much better way of working. So that if there ever was a reclassification case, you're in a much better position to say that you followed a process to come up with that answer, as opposed to just going for whatever was quick and easy and cheap.
Yeah, good. That makes sense. Again, just a quick reminder, we're coming towards the back end of the session now, so we will be moving into Q&A, and we've got some good questions already from the audience, but please do continue to submit them through so that we can cover them off at the end of the session. Charles, I'm going to stick with you. Hopefully your computer or your laptop's going to hold up for the remainder there. We can still hear you okay, but I think a new giant group computer is going to be winging its way to you shortly. But if I can stay with you just for now, can you tell us a little bit more about companies and services provided by EOR and AOR companies? We hear a lot now, I think, in the market about employer of record companies like the one that you run here at Giant Global, as businesses are obviously trying to find talent from different parts of the world. So it'd be great just to understand a little bit more about what these EOR solutions are and what benefits they can present to customers.
Yeah, for sure. So an EOR, employer of record, is, as it sounds, an employed option. Essentially, the worker will have an employment contract. It could be open-ended, it might be fixed term, but every month or week, depending on the jurisdiction, there'll be a payroll run and the worker would receive the net pay along with the pay slip. So all the taxes are deducted at source. I guess importantly, all employer costs would be paid directly to the local authorities, and the worker is able to just focus on their work while all of the, I guess, administration associated with being paid is taken care of for them. Now, the key difference with an AOR solution, agent of record, that's where the worker is going to be operating as self-employed or maybe via a limited company. And so essentially they will be receiving a gross payment, and it's then part of their responsibilities to pay their taxes and social security directly to the authorities. So certainly a little bit more admin involved for the worker or for the contractor with an AOR solution compared to an EOR one.
Cool. Yeah, great. Understood. And are there any other particular forms of engagement outside of EOR and AOR?
Well, generally speaking, we do use EOR and AOR as a bit of a catch-all within the different terminologies that do exist in the different structures. But you could have someone referring to company, there's BVBA, BV sole trader, ZZP in the Netherlands. You can have directly sourced, subcontracted, or consultancy engagements. So there's lots of different terminologies, but the reality is you can probably pair them all back into either an EOR, somewhere in there is an employment infrastructure, or AOR, meaning there's some form of self-employed or limited structure in there. And those are the key ones really, but each country might have slightly different terminologies for how they describe those.
Yeah, it's fun. I was just thinking then as we were going through some of the acronyms that are used within the Netherlands, we love in this world of contingent workforce, we love these acronyms, don't we? IR35, BVBA, EOR, AOR. It's almost like its own language that comes about if you're not used to it in the sector. But you're right, to simplify it, in essence, it's either someone's being engaged like an employee or someone's being paid, you know, as a contractor, and the rest of it is kind of detail around the side. So I think that was really useful. Thanks, Charles. Jorgo, it'd be good to, I suppose, hear from you from a lawyer's perspective on the different worker engagement types and what the considerations should be here as well, please.
Yeah. So I will just sum it up very briefly in order to allow Merel some time to talk about the changes coming up, very importantly for staffing agencies in the Netherlands. So very quickly, there is only 3 ways of engaging with a worker if it's not employment. One, direct self-employment ship. So there is an engagement between the self-employed worker and the client. That's one. Then the second one is put in the intermediary, and there's basically two flavors, which is the temporary work agency or the payrolling agency. These are a little bit the same, but it's technically different, to be honest. But these are basically the flavors that we can distinguish here in the Netherlands. And the self-employed workers often find their way to the labor market through intermediaries, as I said, and typically platforms.
Yeah.
And the platform economy illustrates that very clearly, I guess.
Yeah, we were talking about it, weren't we, before the webinar started? We are all seeing much more utilization of online platforms that can allow companies to gain access to these contingent worker populations, at whether it's gig economy or white collar type contractors. And again, it's interesting that some of those platforms sometimes view themselves as not recruitment businesses, but seem to be very much conducting themselves as recruitment businesses. So I think it's worthwhile mentioning those and making sure that they're being thought about in the same way. Okay, so we're going to move on to the last topic. So I think Meryl I think there's going to be a lot of people interested in this final section, where we're looking at the sort of compliance requirements and responsibilities that there are in the Netherlands for people that are providing workers to companies. So specifically recruitment businesses and payroll providers. And I think you're going to be pointing out that there's some thought here now around licensing arrangements coming into the Netherlands, which will be a new concept in the future. So please just give us an overview of the regulations that we can expect.
Yes, happy to do so. So indeed, there's some legislation coming up, or has been pending for quite some time now. When it's coming up exactly, we don't know, but that is with regard to the licensing. The regulation that is in place is also deserves some attention, because it's important to be compliant with this regulation. So when hiring from user companies, it's like a temporary work agency or a payrolling agency, it is important to make sure that the agency you're hiring workers from is registered in the Dutch Trade Register. It's forbidden to hire workers from an agency that is not registered, and you can also be imposed a fine by the government if you do so as a hiring company. Furthermore, user companies can be held liable for payment of wages and taxes and social premiums, so the premiums for the social securities in the Netherlands, if the user company does not pay these taxes and premiums over the pay of the workers. So for user companies, it's therefore useful to check whether the agency you're hiring from is registered in this so-called SNA register. And such registration in this register is, makes, it's a sign of this agency being compliant with regulations regarding tax and housing, etc. So it's advisable to obtain this registration as an agency and to check whether you have a trusted partner in the agency you're hiring from. User companies, they can be exempted from the liability regarding taxes and premiums by paying a percentage of the sum they're paying to the agency on a special account. This is the G account. It's called the G account. And it's one of the requirements to be able to have such account as an agency is, amongst others, the SNA registration I just referred to. So if you are hiring from an agency with such account, you can. It's often also a sign that they do have their registrations in place. There are a lot of equal treatment provisions in Dutch law regarding temporary agency work and payrolling, which are two separate forms of flexible labor. Based on these provisions, currently there are provisions in place that temporary agency workers are entitled to equal pay in comparison to the employees of the company they are working at via the agency. And there's also there's a collective labor agreement in place in this temporary agency work sector. that has a lot of impact. So it's very important for the employment conditions in this sector. They are regulated to a broad extent by this CLA, by this collective labor agreement. Furthermore, there's a pension scheme applicable for temporary agency work. There will be some changes around this. So there's a new CLA has been agreed upon by the parties, and also the pension scheme will be subject to some changes. So I will discuss that later on.
Okay.
Furthermore, payrolling employees have a right to equal treatment with regard to all employment conditions. So not just salary, which is the case for temporary agency workers, but payrolling employees are entitled to all employment conditions that employees from the company they are working at enjoy, except for pension. And pension must then be comparable to the pension scheme that applies to the employees of the hiring company. So that is already arranged for by Dutch law. So that is even the protection there for payrolling employees is even stricter than for temporary agency workers.
Yeah, great. That makes sense. And I think we've obviously got the agency worker regulations that straddle the UK as well to some extent around treating people equally, whether they're contractors or permanent. So I think those concepts we're familiar with. Thanks, Meryl. Charles, given that Giant Global operate in a wide variety of different countries, we're hearing a lot of different things that need to be considered. So it must be challenging for you to manage. Just tell us quickly about how you and other global employer of record businesses try and manage these complexities, if you can.
Yeah, for sure, it definitely is challenging. Working in lots of different countries with legislations changing all the time. We have a combination of things. We have our own internal team who are experienced in international payment solutions. We, of course, have our proprietary software that we use that allows us to deliver our services globally. But we also have our network of specialists like Osborne Clark who are based locally in each country in which we operate. Essentially, they're able to provide feedback and information to our internal teams so that when things are changing, we can then formulate how we need to adapt our offering to make sure that we continue to provide compliant solutions to our clients. So I'd say this is one of the key aspects of us being able to operate in as many countries as we do. Without our trusted partners like Osborne Clark, it just wouldn't really be possible.
Yeah, no, absolutely. It's a lot to keep on top of. So thanks for that. And I think if we can finish off with you, Meryl, if we didn't already have enough to consider, I think you're now going to delight us with what might be on the horizon for us to consider in the future as well.
Yes, I have some interesting bills to discuss with you. So there is this bill you already discussed, you touched upon shortly, is the bill regarding the admission of companies who are providing workers on the labor market. In essence, this bill introduces the prohibition to provide workers to other companies without being admitted to do so by the minister. And in order to obtain such admission, you have to prove certain things like that you are compliant with labor laws, have been compliant for certain years in a row with social security laws and fiscal laws. Again, this also relates to the SNA registration. You furthermore have to prove financial security, so to be a financially stable company, and you have to provide a declaration of good behavior issued by the government. I think a lot of people who have been working in the Netherlands are familiar with this declaration. It's often something as an individual apply for at the government to show your good behavior, but also companies can apply for this. So that needs to be submitted as well in order to obtain the admission. Well, the status of the bill is quite unclear, so it has been adopted in April 2025 by our House of Representatives, but still has to be discussed and voted on by the Senate, which will take place in October. And then the entry into force date is now set on January 27, so it's quite far. And then not all elements of the bill will be applicable right away. So For example, the ban on providing without the admission will apply as of January 2028. So there's quite a gap until then. More relevant and urgent, as I already said, is the new CLA that has been agreed upon for temporary agency work sector. So now currently, until January 2026, the CLA that applies imposes the obligation to equally to pay temporary agency workers equally in comparison to employees of the hiring company. But with this new CLA, they will also be entitled to equal treatment with regard to the whole package of employment conditions. And this means that the package needs to be equal, and they can, choose to, for example, exchange holidays for extra salary, but overall the package needs to be equal as the employment conditions of employees in the same position in the user company, in the hiring company. Furthermore, the pension scheme for this sector for temporary agency work will be improved. It was always considered to be very below market practice with poor or very low employer contributions. And now it will be aligned with market practice. So this CLA and also this new pension scheme, they impose substantial extra obligations on hiring companies and temporary work agencies, and we therefore advise to ensure close collaboration and cooperation when you are providing or hiring workers, because you are both liable for those obligations regarding equal treatment. So you have to be in close contact to make sure what are the employment conditions we're looking at and that we have to meet. Another legislative development that requires some attention is the platform directive. It's not quite urgent right now, but it needs to be implemented into Dutch law, and it can also affect flexible labor relations like temporary agency work, as it has been discussed often that it actually in essence is just temporary agency work. And last but not least, I think we've discussed it earlier as well, but the EU Court of Justice has announced that temporary agency work must be temporary, which means that hiring to a hiring company must be limited by a certain amount of time, for example, 3 years, which is not done now by in Dutch law. Dutch law does not has such limitation, and our government has said that they will be taking, these EU developments into account when making new legislation. But until now, there's no concrete legislation, but we're keeping a close eye to it.
Brilliant. Yeah, no, thanks, Meryl. Super complex, and obviously the pace of legislation just seems to move quicker and quicker as we progress. So it's good that you're giving us some early insight into some of the developments. Thank you, Meryl. Thank you, Jorgo. Thank you, Charles, for your contributions to the topics. That we're now into Q&A. So we've got a few minutes to pick through some of the questions that the audience have been kind enough to pose as we go through. If there are any questions remaining we don't get to, then we'll make sure we share some answers to those in the follow-up. So let's jump in here. Question first of all, is there a risk for self-employed workers who are working for a Dutch company via FEX, a Belgium intermediate company? So maybe one for Jorgo or Meryl. Is there a risk for self-employed workers who are working for a Dutch company via a Belgium intermediate company?
My initial thought is the risk is not so much for the self-employed workers, but for the Dutch end user, right? Because as soon as the Dutch end user engages on Netherlands soil with a worker, regardless where he or she is coming from, it's about the law of the land. Then the risk is for the end user to be reclassified as an employer.
And all the usual tests that we've just been talking for would apply to that engagement, basically. So I think I would agree with your answer there, Jorgo, certainly. Next question from Abby has asked, as a recruitment business looking to place UK PSCs, limited companies, into the Netherlands, would we be considered the intermediary or client of the PSC? intermediary or client?
Yeah, so I had to look up PSC.
Yeah, me too.
Because it's
Personal
Enlighten
service
me.
company, Manco, I think you might refer to them as in the Netherlands, but an individual working through their own limited company.
exactly. Yeah. So
Yeah.
we would say no. So no, I would actually say that it's an intermediary at first sight.
Yeah.
But we would have to have a closer look to make sure in order to get 100% compliant answer. But my immediate thought, like you, Dan, was intermediary.
Yeah. So the contract chain will probably be something like a hirer into a recruitment business who is then contracting to a limited company, but it's a one-person limited company with a contractor engaged as its director. That's typically what we see in the UK. So I think we're right to say you'd be considered the intermediary. The client ultimately is going to be the end hirer who's receiving the benefit of the services. Okay, let's keep going. Charles, sorry, yeah, come in there.
I was just going to say that point as well. If you're placing a UK limited company contractor into the Netherlands, you should certainly still be doing all of the compliance checks that we talked about to make sure that it's the right type of engagement for that worker, and that they're not under kind of, in easy terminology, the supervision, direction and control, all the things we discussed earlier. The other side of things that you need to be concerned around is if that individual is physically based in the Netherlands, then you're looking at the 183-day rule, which if you go past, then there's a tax liability in the Netherlands anyway, even if you're paying to the UK limited company. And you've also got the potential social security liability from day one, unless that PSC also holds an A1 form to show that they're paying their national insurance back here in the UK, as opposed to having a liability in the Netherlands from day one. So I think you've got the classification as one point, and then you've also got the length of time and the social security to consider as well as are you actually an intermediary within that contract chain. So there's probably quite a few moving parts to think about with that type of engagement.
Yeah, no, that's a fair point. Obviously, if it's a UK contractor using a UK limited company, they need to be registering for social security in the Netherlands, as well as the other points that you've mentioned there. Okay, let's keep going. Yeah, a few of you asked, will you get a recording? We will follow up after this session with a recording to everyone who's registered, and again, any outstanding Q&A we'll address as well. But I think we've only got a couple more to get through. So we have another question here from Claire. Hi, Claire. Does DBA legislation also apply for a Dutch-based self-employed contractor working for a UK agency client? So we've reversed it now, Jorgo and Merrill. We're now thinking about whether DBA applies for a Dutch-based self-employed contractor who is actually delivering work for a UK-based agency. What's your view on that one?
Yeah, so it would always depend on the applicable law. So when you are based, typically it's the law from where the worker performs the work. But you know, it requires a closer look to the contract because there could always be exceptions or exceptional circumstances making another law, making it more likely that the law of another land applies. But if Dutch law applies, the provisions of Dutch law will apply as well.
Yeah, that makes sense. I think as a general rule of thumb, then it's where the work is being done. But you need to be into the detail on the specifics of those arrangements to understand which countries' laws apply.
Yeah, and whether exceptions may apply.
Yeah.
Yeah.
Okay. Thank you, Merrill. Okay, last question, I think. Sophie has asked, in the Netherlands, our company does not have fixed working hours or vacation days. Staff work flexibly without accruing holidays. How does equal treatment, which you were talking to us about, Merrill, apply to payroll employees in this case? Are we legally required to provide them with statutory vacation days and working hours, even if our own employees do not receive them? And does it differ between payroll and temporary workers?
Yeah, so as said, the total package needs to be comparable, needs to be equal. For temporary agency workers based on the new CLA, so as of January 26. For payroll employees, the Dutch law already states that they need to be treated completely equal. Statutory vacation days always need to be offered. It's the bare minimum. And of course, you can agree in your own company that there, for example, are unlimited holidays and therefore not a minimum, not a maximum, but you always need to enable your staff to enjoy the statutory minimum, which is 20 working days when working full-time per year. Are we legally required to provide them with statutory vacation days and working hours? Yeah, so you need to make sure you're compliant with the mandatory Dutch law provisions. And an example thereof is also the Working Hours Act. So working hours are regulated to a certain standard in that act. So you need to make sure you're compliant.
Okay, understood. James, Dawn, Kevin and Colin, appreciate we've not got round to your questions, but what we'll do is we'll circulate them between the group and we'll put those answers together and put them in the follow-up. So don't worry, we'll get back to you on those questions, but we do need to be conscious of time. That runs us to the end of today's session. Meryl, thanks very much. Jorgo and Charles, thank you also for your contributions. Super helpful. As I said, we'll do a follow-up. You'll get a copy of the recording and we'll hope that everyone enjoys the rest of a sunny afternoon. Thanks for attending, everyone.
Thank you, Dan.
Thank you, Dan. Bye.
Bye.
Bye-bye.